there, warm welcome. You're watching Blueprint Explosive Exclusive with me, Meghna Deka. Well, viewers, today, this evening, I have some news for the 500 million WhatsApp users in India. But what if I told you, Meta has been fined 213 crore rupees for breaching our privacy, for giving away our personal data without asking us. Well, India has made it very clear that WhatsApp's take it or leave it policy will not work here in this country. WhatsApp cannot anymore share your data without your permission. Remember the new WhatsApp private policy that had come out in 2021. All of us were constantly at the time getting notifications from WhatsApp. We were asked to agree to the terms or else we won't be able to use the app. So under pressure, under duress, all of us were forced to accept those very norms, because today WhatsApp is the most important mode of communication for most of us. In fact, let's also tell you how, due to this policy now, India's competition watchdog, the CCI or the Competition Council of India, has imposed a penalty of 213 crore rupees on Meta. The social media giant has been fined for abusing its dominant position. And look at the very strong words which have been used by the CCI in that. It says that it has used its dominant position, and not just this, Meta has also been asked to implement behavioral remedies as well. In fact, before I tell you more about the directions for Meta, I also want to tell you a little bit about the case for which Meta has now been filed over 200 crore rupees. In fact, let's tell you about the privacy policy. The privacy policy of August 2016, WhatsApp users were given the option to decide whether they wanted to share the data with Facebook or not. They gave us, the users, an option here. This was the option in 2021. In January 21, WhatsApp then notified all the users about its new policy and the updates. In February, there you have it. The in-app notification had said that if the users want to continue the app in India, then the users will have to accept the new terms. This happened in February 2021. The new terms included mandatory data sharing with all the Meta platforms. Of course, that means that any data which WhatsApp has, they would be using that across in Facebook as well. In fact, it was as if WhatsApp was saying, take it or leave it. And that's precisely what the CCI has said. So the data sharing on other platforms of Meta became mandatory. The users were then forced to comply. Now India's competition watchdog has cracked the whip. 1, Meta has been fined. 2, this you have the details as to what exactly it is that CCI had said. 2, WhatsApp has been told that it cannot share your personal data for advertising with other Meta platforms for 5 years. So for purposes other than advertising, the policy must include an explanation of the user data being shared, and WhatsApp has to link each data type to its intended purpose. So essentially, you will be deciding whether your data is going to be shared on other platforms of Meta or not. And this, as you can see, the CCI has made it very clear to Meta, if you want to run in India, these are going to be our terms. Let's also, however, tell you what Meta has said now. It has completely disagreed and has now planned to appeal. This is the Meta statement which came in right after, the day after a fine was imposed on it. In fact, let's decode what this means for the users, for our guests. This is what the Meta has said. It says that we have ensured that no one would have their accounts deleted or lose any of the functionality of WhatsApp services because of this update, was one of the points that they had made. So let me go across to our guests to try and decode what all of this means for you and I. How much of our data has already been shared and what the privacy concerns are. We are today joined by N.S. Napinai, a senior advocate of the Supreme Court. Shri Partha Sarthi is also joining us, a partner and leader of the Digital Trust and Transformation. Well, I'm going to come across to you, Ms. Napinai, first, because we are going to read what Meta has said in its clarification. While CCI has said that this was a take it or leave it policy by Meta, Meta has said that the 2021 update did not change the privacy of people's personal messages, and it was offered as a choice for users at the time. We also ensured that no one would have their accounts deleted because of this update. Where do you weigh in here?
If you remember the background to how that happened, initially WhatsApp actually changed its privacy policy without giving us this opt-out provision. An opt-out provision means that you will continue to have the usage of the service, but you do not have to agree to the change in the privacy policy. Now, this is an option that was already available to users in the European Union because the GDPR mandated that. The way the tech platforms interpreted the laws, the extant laws at that point of time in India was that they could continue to insist that either you agree to our privacy policy or you will have to discontinue the service. It was only after there was a protest against this option, and where, if you remember, there was a huge protest where people started migrating out of WhatsApp. And a lot of us, we started discovering or we started making other alternatives the primary option going forward. And at that point of time, Meta then offered that they would continue the services without disruption, even if we did not accept the changed policy. But many of us who opted for that option, that we refused that, do not have a lot of functionalities which other WhatsApp users may have today. So that's how they kind of limited our rights, but at least the service was still continued. So my take, Meghna, is this, that yes, it was continued, but it was not continued without a fight.
Okay, so that's very interesting because that is contrary to what they have claimed now in their appeals that they are going to be making, that there was no disruption of services. However, there were certain conditionalities, as Ms. Napina is explaining to us. Now, Shri Partha Sarthi, it's very interesting. Meta, in their response, in the statement that they have put out, one of the things that they have said that it's all about transparency. Isn't it ironic? They say that the update was about introducing optional business features on WhatsApp, provided further transparency about how we collect and use this data. What was this data? Shri Partha Sarthi, if you can explain to our viewers, everyone who's been using WhatsApp since 2021 and much before, what is this data that they have already provided to their partner platforms without asking?
Yeah, I think the interesting part is most people who use WhatsApp or Facebook or Insta do not really understand that they are all connected in integral part of Meta. So I think that's the fundamental issue there. Second is people, as they basically are chatting on WhatsApp, and as they're providing a lot of information, because people use it for personal use, they use it for business, and they use it for a lot of things, and a lot of things transpire there. So there's amazing amount of information that is there, and WhatsApp also, in some cases, if you allow, it can also track your location services and other things. So when you start thinking about it, the profiling of a user becomes complete. On one side, you have Instagram, you have Facebook, which are basically, I call as sort of not offline platform, but they are not actively tracking your particular location as you basically move and other things. But when you look at WhatsApp and other things, becomes a true online, and it can actually track what you're doing on a regular basis. And now, as you look at it, when your personal information, your location information, your buying patterns and other information are being shared, then what WhatsApp is now, as WhatsApp and the others start sharing the information, now they have profile information, they have your preferences. Now they can start advertising to you very, very targeted in terms of what you're looking at. So in that particular case, what happens is now that particular data, the reason all of them are why Meta is providing all of these platforms free is because you are the guinea pig. They are using your data and then essentially positioning that with advertisers and saying, hey, I have this large user base and I know what are their buying patterns, and now you can put across whatever advertisement you want. Now, if I come to the Competition Commission's angle,
Right.
Competition Commission angle should be that Meta should be providing this particular platform and data to everybody so that the advertisement and other thing, if anybody wants to do, should be equal from that aspect, and that is what they should primarily look. I think more than the Competition Commission, I think what I would point out to is the DPDPA. Even today, we do not have the rule sets which are governing the data sharing and all of that. If DPA had been in place today, we would not need to go with Competition Commission to actually try and track some of this particular information. What we would need is we could actually impose DPDPA on Meta and tell them that what they can share, what they cannot share, what is PII, and all of those particular things. And there could be even more severe penalties on Meta in that particular angle. I think on one side, we are leveraging Competition Commission, but actually the true problem is the privacy and security of our particular data and the PII that is getting shared underlying this particular platform.
I absolutely agree with you. It's not just about sharing data within their platform, but also the data which has been acquired by us and then being shared outside. There are larger ramifications. Ms. Napinai, would you also concur that perhaps India, if today we had stronger laws, we could have ensured that these global giants who have this advantageous position, the dominant position that they are misusing, could have been curbed? Because there was a similar ruling against Meta, wasn't it, by the European Union and Ireland as well?
Absolutely right. And Meghna, you are lucky today you have a panel who is broadly in agreement on most of the issues. I would only want to clarify a couple of things.
Right.
The first is the Competition Commission's jurisdiction is very different from that of the DPDPA. For those who are uninitiated, it refers to the Digital Personal Data Protection Act, which has been passed but not yet implemented. So the Competition Commission and Parthsarathy set out the background to it very nicely. What he mentioned is the reason behind the CCI's judgment itself, which is that when you're triangulating this data beyond, and this is what is called as both the consent and the purpose limitation. So did I consent to this triangulation, or did I only consent to my data being utilized only within WhatsApp for the purpose of giving me WhatsApp as a service? So that's where the violation has been pointed out by CCI. We'll have to wait to see what the appeal has to say, but this is the basis for it.
Absolutely.
The second aspect is what CCI is relying on is that when you triangulate this data, you then you misutilize your dominant position as a large player to collate and utilize data which may not otherwise be available to single players. It's almost like pitching a single screen theater with a multiplex. Right. If I were to give a very simple example. Why I'm saying I'm digressing a little bit whilst agreeing is, you know, in law we always assume it's alternatives either or. It is not so. You have both your remedies. Where a company violates its dominant position, then you come under the antitrust laws of the CCI. Where you have violated personal data beyond the data principles, what is permitted for you, then you come under the PDP laws.
Right.
So whilst we all want the DPDPA to come into effect at the earliest point of time, the issue we are talking about goes back to 2021. So that will still be governed by the data protection laws as on that date, which is the
would not be retrospective.
Section IT Act and also the rules framed thereunder. But it is not like it was a weak law even then, as is perceived, you know. It was a single provision, but the rules framed under it was quite extensive and it covered all the data principles. But we did not have the opt-out provision the way European Union has. And sadly, going forward also, if you ask me, unless the rules are going to somehow fit it into the very bare bones law that we already have in place, the DPDPA also falls short of that golden standard of GDPR. So I'm really waiting to see how the rules are going to flesh out this bare bones law, because without the rules, we are really not in a position to say how strong our laws are. But
Absolutely.
final point here is, we really should appreciate the fact that finally there is a judgment which kind of lends fillip to the fact that people should take our personal data seriously. People should take our rights seriously and should not violate it with impunity. If you do that, there is a price tag to it. And
Absolutely. And a price tag that we have, perhaps we're not even going to realize for a very long time, the way it is going to come in, the triangulation of data, as the two experts have explained to us, because you literally, every little detail of your life would have been shared between at least 3 of these platforms of Meta, be it Facebook, be it WhatsApp, or be it Instagram. But Sri Parthasarathy, now many of the people are sitting there, they must be watching the show and saying, in 2021, I have perhaps said okay to it. At that time, many people did not even realize what the implications of this in the long term would be. They are wondering today, what do we do? What is the damage which has been done to us already? And is there anything corrective that we can do at this point?
Incidentally, what happens is, and I think this is not anything against Ms. Napinai or any of the lawyers at all, but I think when you look at a lot of these particular policies and other things that are given to an end user, right? They are fine print. And when you get a credit card today, you get like a 20-page document. I don't think anybody really reads that entire 20-page document. When you go into court, they'll say you should have read that, right? But it is in such small font, and that's the fine print that they primarily give, right? And that's the disclaimer. And similarly, when you look at these particular platforms, if you want to today opt out, or if you want to do something, what you did, or undo something that you did in 2020 or 2021, I will tell you that it will be a very difficult thing to do unless they basically are forced to basically put it on the front page to say, if you want to reconsent, or if you want to do that, please go ahead and do that right now, right? That is the biggest challenge. And most of these particular applications, if you really start searching, most normal users will not be able to find it. And which is where I think the challenge is going to come for people to be able to do that. So if they were to provide you that option, then what can be done? A person can go in and opt out even at this point and say that I do not want you to share information. Even though I have 3 accounts, I do not want you to share the information. Second is, if you've captured some particular information of me, I would like for you to either purge it or disclose to me as to what is that particular information that you basically have, so that you then I can make a decision on that particular point. And the last is based on DPDPA. If they do not do all of these things and do not come back to you acknowledging this particular fact, then at that point in time, when the rules are out, you could potentially take them to court for that.
Okay. But that if and only if Meta provides that kind of an option, even as we speak today, Meta says they're going to appeal against the CCI's fine as well. Ms. Napina, you wanted to come in?
Yeah, I wanted to say that it really would be contingent on a law coming into place. Because by themselves, no platform is going to give you that opt-out. So if you just remember the 2-year window which GDPR gave from 2016 to 18, predominantly this is what we face. You would have got at least 10 to 100 emails every day asking, why was that so? Because the rules were different prior to that, and under the GDPR, there was a more stringent consent framework, and it was also interpreted as consent or nothing. And therefore, they immediately, each platform thought they had no choice but to come back to you for that consent. So for that change, because your question was wonderful and very critical at this point of time, and I personally feel we are all dependent on a strong law to come in, and that would be visible only after the rules are framed under DPDPA. And we'll have to look out to see whether that's going to mandate not just Meta, but any platform to give us a relook at the terms and conditions.
Absolutely. That's a very important point. Sri Parthasarathy, I wanted to discuss that. It's not just about Meta, is it? When we are talking about a possibility of sharing our data with aggregators that we have not agreed with, it is happening even now with others as well. Do you think we can leave it to the global giants to give us an opt-out option at this point? Should the government step in? And also tell us about the other threats which are looming in the shadows.
So, Meghna, I think one of the most positive aspects that I see since I'm working with a lot of organizations right now, whether they are in financial services like insurance companies or retailers and all things, and many of these particular companies are not waiting for the rules.
Hmm.
They are looking at interpretation of the law as it is, and they are looking to actually become ready in terms of compilation of all of this data. First and foremost is what you don't know does not hurt you, right? So first and the foremost is the discovery of the data. Second is essentially identifying what is that particular data which comes under the DPDPA and what is the classification of that particular data. Does it fall under PII and other thing? And third is for them to be able to then go back to those particular customers. And I think I would say that what I'm very happy is most organizations are already actively working on it.
Right.
And I think those are the early adopters. Now, coming to some of these other giants and all things, they are going to hide behind this, but I will tell you that if we are stringent and if we are very firm about it, they will come to terms in terms of what they need to do from an India perspective. So I think
that'll be
the
interesting
law,
to see if this 213 crore fine on Meta by the CCI is actually going to be a big message that is being sent out by India. But of course, we'll have to wait and see if it actually is going to help ensure that our data is safe. Well, appreciate it a lot. NS Napinai for joining us, Sri Parthasarthi for giving us a perspective, not just about the problems that we've already had with our data being shared across since 2021 across WhatsApp and Meta platforms, but also what you can do about it now.